Today we are going to examine the claims of the proposed class settlement. The topics of slides and discussions are about a legal matter. None of the information provided is an official legal opinion or any kind of offer to provide legal advice. If you require legal advice, please hire an attorney and show them this informational presentation, which will be available on our website and YouTube channel. The slides and discussions are for informational purposes only. Distributors in Illinois, Massachusetts, and California should have received a packet from the court on how much potential money is involved in the $22.5 million settlement. It is extremely important that you review this information with your attorneys so you understand the ramifications of this preliminary approved settlement before the judge makes a final decision. This presentation will examine the statements of claims from point 7 as well as the fine print of the new contract. But before we begin, let's start with a recap. This settlement is from employee misclassification lawsuits that were filed in these 3 states starting back in 2013. Do you remember why lawsuits were filed? Plus out of orders, service frequency standards, route rides, ticket count, planogram compliance. Basically, Pepperidge Farm treating distributors like employees without the benefits. To be clear, POAA does not object to Pepperidge Farm paying distributors and settling the employee misclassification lawsuit. POAA objects to Pepperidge Farm dangling that money to hook distributors to accept a new radically different contract, which we will go over some of the more alarming points in this presentation as well as the claims made in the notice. Remember, the devil is in the details, and you and your attorney should do a side-by-side comparison of your current contract and the proposed contract you will be receiving. Remember that the notice was written by the class attorneys who will only benefit financially when this settlement receives final approval. So keep that in mind while reading the claims. In its entirety, including distributors receiving a new contract, POAA believes the settlement isn't fair, reasonable, or adequate, and this presentation will elaborate. But first and foremost, there is no valid reason for a change of contract when the entire scope of the lawsuit dealt with employee misclassification. Don't be fooled. Our current contracts are much stronger and offer more protections than the proposed contract. When viewing the new proposed contract, the class attorneys make several claims that appear beneficial to the distributor at first glance. But using experience as our guide, a critical eye will see that this is nothing more than an illusion. Here is an example of what I mean. What is a territory? The area in geographic terms that is assigned to a person or agent. It is found in several places in our current contract. The title page, in the definitions of the contract, and Schedule A, which is a written definition of the geographic territory. Why is this important? Pepperidge Farm reinterpreted the word territory and the phrase or any portion from paragraph 20 of the Blue 2001 contract to mean a channel such as a club store to do a forced buyback program of snack distributors' most profitable accounts. Remember that we own geographic territories, not accounts or stores. If Pepperidge Farm could reinterpret the word territory in our current contracts, what could they exploit in the revised version? Again, keep in mind that this notice was written by the class attorneys who will be rewarded over $5.5 million. And the $22.5 million that Pepperidge Farm is spending just to have this case go away is just a fraction of the total exposure of cost if this case were litigated to conclusion. While the settlement amount seems large to the average person, it represents only 1.1% of Pepperidge Farm annual sales. Point 7 of the notice claims the revised or amended consignment agreement provides current distributors in California, Massachusetts, and Illinois with new rights, and makes clear Pepperidge Farm does not exercise control over the manner and means by which current distributors perform service through the addition or subtraction of numerous contractual provisions. What the notice fails to mention are the rights that distributors are forfeiting and the rights that Pepperidge Farm is gaining. We will examine 8 statements raised in the notice to see if they are accurate, as well as some of the rights and financial benefits that Pepperidge Farm gains. For this presentation, we will examine the 2001 Red Line Blue Agreement because this will be the new standard for everyone if this settlement is approved in its current form. The first claim deals with plus outs and Pepperidge Farm notifying the distributor and the distributors having the ability to reject product if sufficient notice is not provided. This is found in paragraph 2. Under quantities consigned, notice the word accept has been changed to order. This gives the appearance that Pepperidge Farm will no longer force product on distributors that they didn't order. That sounds great, but what right do we currently have that you might not even be aware of? Our current contracts state that Pepperidge Farm reserves the right to allocate its products as nearly proportionately as practicable if the overall demand for its products exceeds its production. Pepperidge Farm currently does not have the contractual right to plus any additional product to distributor orders. Allocation and plussing are 2 separate terms with different meanings, and plussing orders is not in our current contract. If we look at a few sentences later, it states that if a distributor refuses plus out product, Pepperidge Farm shall have the right to distribute that product as long as the consignee opts out. In addition, you will not receive commission on this product. We also find an easy way for Pepperidge Farm to avoid the notification requirement in this section, where it says Pepperidge Farm must give 7-day notice of plus out product unless if doing so is demonstrably commercially unreasonable. What is commercially unreasonable? It is not defined. So if you refuse plus outs, Pepperidge Farm will get product to your stores, probably by direct shipment, and not pay you anything. And Pepperidge Farm doesn't need to give you 7-day notice of plus out if it is commercially unreasonable. What happens to the leftover product when the promotion ends, or is damaged during shipping? The notice states the distributor is gaining a right to refuse product, while actually you just agreed to let Pepperidge Farm plus your orders, or you forfeit commissions. This benefits Pepperidge Farm more than the distributor. This claim states a significant reduction in record keeping. Let's examine this more closely to see if it is true. While Pepperidge Farm will only require you to keep records such as invoices for 12 months unless there is a dispute, this so-called right is irrelevant as most state and federal regulations require tax-related records to be kept for several years, including invoices. Also notice that inventory checks, which are currently done on a yearly basis for most, has been changed to twice a year. Another right granted to Pepperidge Farm. The next 2 points are covered in the same section of the contract and are also misleading. This is found in paragraph 4C. But first, notice the change from effort to results. Words have meaning, and the slight change has a dramatic consequence. The distributor is guaranteeing the results, not just giving their best efforts. Yet another benefit to Pepperidge Farm. Here we see the phrase, provide distribution services to all retail stores on such days of the week, including weekends, was removed. However, notice what is inserted. Recommend service frequency, day-a-week standard, route rides, which isn't defined and is now part of the contract. Isn't this one of the reasons why distributors felt like employees in the first place? Now distributors are agreeing to these stipulations. Why? While the appearance is less oversight, Pepperidge Farm will have greater control of your business day-to-day operation. Now, Pepperidge Farm claims that you will not receive any adverse consequence if you don't follow these recommendations. What is an adverse consequence? This term is not defined, and how exactly does a distributor contest the consequence? Notice that Pepperidge Farm may from time to time publish sales and promotion information. The legal definition of may is a choice to act or not, or a promise of a possibility, as distinguished from shall, which makes it imperative. Again, words have meaning. Why isn't Pepperidge Farm contractually required to provide sales and promotional information? A new provision claims that it authorizes distributors to negotiate planograms directly with the local stores. Is this true? This is found in another section of paragraph 4. It says that you will have the right to alter planograms if a manager approves the form provided by Pepperidge Farm. What does this form look like, and why isn't it included in the contract? Pepperidge Farm will then take the form that no one has seen to the store's corporate headquarters, and if they agree, well then you're all set. If they don't, you agree to keep the planogram and not modify it without exception. How many managers will sign a form knowing that Pepperidge Farm will take it to headquarters for approval? Planogram compliance is another example of Pepperidge Farm gaining more control of your business that they presently do not have. Let's examine the supposed new rights granted by the contract, one dealing with approval of workers and the second with damaged product. The proposed contract claims that it is giving you new rights that you already have. Needing Pepperidge Farm permission to hire employees is not a new right. Our current contract states under paragraph 12 that distributors have the permissions to hire anyone as long as they don't fall below standards in keeping with the established reputation of Pepperidge Farm. By the way, what are those standards? In regards to damaged product found in paragraph 27, haven't you always had the right to ask for forgiveness? Pepperidge Farm always had the discretion to grant forgiveness or not. This is smoke and mirrors and not new rights being granted. Now we will examine a new right on commissions for recalls to see if it is beneficial to distributors. This is found in paragraph 25. The stipulation is you have 24 hours from notice to remove all recalled items, and all for a 2% commission. Who can physically do that? There are some major benefits granted to Pepperidge Farm that will make the $22.5 million payment seem like an investment, as they will reap more financial benefits in the future. Somehow the notice forgot to mention these benefits, such as authorized deductions, forced arbitration, and no more class action lawsuits. We will start off with authorized deductions found in paragraph 24. Distributors agree to the following charges: over thrift allowance, pallet fee, maintenance fees. Yet there is no thrift policy contained in the proposed contract. Nothing stated on thrift items from direct ship products. Pallet fee costs are not stated. Maintenance fees are now mandatory and not stated. Would you sign a contract for anything that doesn't have the cost listed? This is an open-ended contract that truly benefits Pepperidge Farm. The exclusive alternative dispute resolution process class and collection action waiver found in paragraph 28 is extremely troubling and could be renamed the "See You in Arbitration Clause" because court of any kind is no longer an option. This is another benefit to Pepperidge Farm, as they will save millions avoiding costly litigations. In this section, the distributor agrees to binding arbitration instead of litigation of any kind. Legal court action is no longer an option for the distributor in this contract. Item 5 is very disconcerting. Notice the highlighted phrases. The arbitrator shall maintain the confidentiality of the hearing. The arbitrator has the authority to exclude witnesses other than a party and the party's representative. The arbitrator has the authority to decide whether any person who is not a witness may attend the hearing. So no witnesses to the hearing, and the decision can be kept confidential. Ask yourself, who does this benefit more, the distributor or Pepperidge Farm? You are agreeing to give up the right to a trial by jury. But it gets even worse in the next right granted to Pepperidge Farm, which we will touch on in a few minutes. Again, the distributor is forfeiting their right to a trial by jury in a process that is 1/3 or 6 pages of the contract. There are articles and research papers available online that have similar conclusions as this LA Times article from June 5th, 2019. Chase says arbitration provides better outcomes for consumers. Nope says researchers. Here are a few quotes from that article.
A recent academic study confirms what consumer advocates have been saying for years. Mandatory arbitration is a rigged system. Rigged, that is, in favor of businesses. The whole game is stacked against us, said Amit Saru, a financial professor at Stanford University's Graduate School of Business and a co-author of the study. Remember, Pepperidge Farm is paying for the arbiter when reading this next quote. They found that companies routinely pick arbitrators with track records of making industry-friendly decisions. They also found that arbitrators know that the more they rule in favor of businesses, the greater the likelihood they'll be tapped for future cases and future paychecks. This is not like having judges who get paid the same no matter what happens, Saru told me. With arbitration, you only get paid if you're selected as an arbitrator. They have incentives to slant towards the business side because they know that those who don't do so won't get picked. Not only do these provisions prevent you from filing a lawsuit in the event of a grievance, they block you from joining others in class action suits, thus denying you access to the single most powerful recourse open to consumers and employees.
And our last example that clearly benefits Pepperidge Farm to the tune of millions of dollars, class action waiver in paragraph 29. The title of this paragraph says it all. Distributors will not have the ability to join with other distributors in a lawsuit or class action lawsuit against Pepperidge Farm ever. Distributors must use the arbitration process in paragraph 28. If this clause was in our current contracts, we would not be here today, as there would not have been any class action case against Pepperidge Farm. If approved, this settlement would only pertain to those distributors in California, Illinois, and Massachusetts. Should owners in other states band together to form a class seeking to overturn the loss of club stores and future club store rights, payments per price bulletin, not invoice, or any other issue, those who accept this settlement will be excluded not only from participating in the lawsuit, but also from receiving any award or being part of any judgment. But rest assured, if this settlement is approved, this will become the new contract whenever someone splits or sells their territory. How will this new contract affect your selling price? The amount of rights lost in your current contract dwarf the few positive aspects of the settlement. But again, ask yourself, why a new contract for a case that involved employee misclassification where Pepperidge Farm doesn't admit any wrongdoing, not even an apology? What is your current contract worth? How much would Pepperidge Farm have to pay if they wanted to buy you out today? Our current contracts state that Pepperidge Farm must purchase your distributorship at fair market value plus 25% premium. In this example, let's say we have a $10,000 weekly route at a route ratio of 35-1. The route value would be $350,000. Under our current contract, Pepperidge Farm would have to pay a 25% premium, which would increase the price to $437,500. So the premium is an additional $87,500. While there are several factors to determine the exact settlement payout, the average payout in Illinois will be about $15,000. Pepperidge Farm is getting distributors to accept a new, weaker contract and saving on average over $72,000 per distributor by not exercising their current obligation to purchase the route at a premium. A huge advantage for Pepperidge Farm. I didn't see this mentioned anywhere in the notice written by the class attorneys. Can you see why Pepperidge Farm wants to settle? They get a lawsuit to go away for pennies on the dollar exposure, as well as the ability to plus orders or go straight to market if distributor refuses. Distributor guaranteeing results instead of best efforts. Mandatory service frequency and day-a-week standards despite what the notice says. Route rides which aren't defined. Recommendations of territory splits. The ability not to publish promotional information. Planogram compliance. Authorized deductions. Forced arbitration. No more class action lawsuits. Getting distributors to accept a new contract without paying the 125% premium. POAA does not object to Pepperidge Farm paying distributors and settling the employee misclassification lawsuit. POAA objects to Pepperidge Farm dangling that money to hook distributors to accept a new, radically different contract. We believe the best course of action is to opt in to the settlement, but file an objection to being forced to accept the new contract. Our attorney, Fox Rothschild, can assist you in doing this at POAA's expense.